To kick things off, we'll start with the opening remarks by Azam Ghani, founder and director of International Intellectual Property Law Association. Let's warmly welcome for opening remark for the morning.
Good morning, distinguished delegates, eminent speakers, colleagues, and friends. It's truly an honor to welcome you all to the 24th IIPLA USA 2024, right here in the innovation epicenter of the world, the Palo Alto, California. For those of you visiting for the first time, welcome to the land where a brilliant idea is sketched on the back of a napkin can turn into a unicorn. And for the returning attendees, welcome back. I think I speak for all of us when I say that Palo Alto's coffee is as strong as the tech startups. So we are in good hands for the next couple of days. We gather here at a pivotal time for intellectual property law. The rapid advancements in AI, blockchain, and biotechnology are rewriting the IP landscape faster than we can say patent pending. So just last month, we saw the European Commission rolling out new guidelines on AI and IP policy. A reminder that the rules governing our innovations are evolving as quickly as the innovations themselves. The question is no longer about what can we protect, but how do we stay ahead of the curve? As we dive into this exciting event, we have a comprehensive agenda lined up that will tackle these very questions and more. We're bringing together thought leaders, legal experts, and innovators to discuss the future of IP rights and litigation, from AI's impact on patent law to data privacy in the digital age. Every session has been carefully curated to spark new ideas and create solutions that can be implemented globally. Now, I have heard some of you wonder, will AI replace IP lawyers? Well, here's a little secret. AI can draft documents, analyze data, and even predict case outcomes, but it still cannot negotiate like us or pull off these snazzy conferences badges. So rest easy, friends. The robots are not coming for our jobs as of yet. A huge thanks to our sponsors, Solve Intelligence, Mentaso IP, Patent Zoom, and patent drawing experts. Your support has been instrumental in making this event possible. I would also like to express my deepest gratitude to everyone behind this conference, be it the organizing team, board of advisors, and the team members who are working tirelessly behind the scenes. Your dedication ensures that IIPLA continues to be the leading platform for meaningful discussions and partnerships in the IP world. As we kick off the 24th IIPLA, I encourage each of you to engage, debate, and explore. Whether you are discussing the latest IP policies or catching up with colleagues over coffee, these are the moments that shape our future. I truly believe that the conversations and the collaborations happening here will have a lasting impact on the global IP community. Once again, welcome to the Palo Alto, and let's make the 24th IIPLA 2024 an unforgettable experience filled with insights, connections, and perhaps a little bit of fun along the way. Thank you, and I look forward to meeting with all of you throughout the event. Thank you.
Thank you for the wonderful remarks. Now we are ready to dive into our first session of the day, Future of Innovation, AI, Biotech, and the IP Landscape. For this, I would like to invite our moderator, Denzel Abi Cadet, Managing Member of Cadet Legal PLLC from US. Let us welcome our panelist, Dr. Vishal Sharma from Methonia Inc., USA. Jacob Ville from Page Whiteferrer, UK, and Deepthi Tayar from Ingenious eBrain from India. I welcome you all.
Good morning. Can everyone hear me? Great. I'm really excited to be here. My name is Denzel Cadet, as they said, and I'm the managing member of my own firm, Cadet Legal. I'll go ahead and tell everyone right now, I am not an IP attorney. I am a corporate transactional attorney. And my background, I started out at a big international law firm in New York, working on billion-dollar asset management deals and acquisitions. And since then, I also worked at a Silicon Valley-based tech firm that you would know, where I got more exposure to the tech world, startups, and VC. But the thing that my practice, that's essential to my practice and that brings me here is my clients, the central focus of their businesses tends to be assets, right? Management of assets. And we think about a lot of things when we think of assets, but among those are intellectual property assets. And so the world of IP with my startup clients, including a number of AI clients, some crypto clients, has really fascinated me. And I look forward to kind of serving a similar role as I do on my field in this panel, which is kind of directing traffic and letting these experts here really shine and show their expertise. So I'd like to introduce the panelists. First, we have Dr. Vishal Sharma. He is a networking technologist who solves complex or intractable technical challenges in high-stakes environments for telecom and networking executives when key tactical or strategic decisions are stalled or in make-or-break patent litigation and investment. He does so using his reverse engineering acumen and 360-degree industry perspective. He has 12 issued US patents and has a deep interest in the confluence of intellectual property and emerging technologies. Next, we have Deepthi Tayal. She is a PhD in biotechnology with over 18 years of experience in IP and business consulting. She is the CEO of the organizations Ingenious, eBrain, and Esamine. Ingenious is a boutique consulting firm that supports organizations in analyzing and predicting the future of IP, technology, market, and business models for strategic decision-making. And Esamine harnesses the power of AI to unlock the true potential of data. Last, and certainly not least, we have our colleague from across the pond, Mr. Jacob Willey. He's a patent attorney who works for Page Whiteferrer in their London office. Page Whiteferrer is a leading firm of specialist patent and trademark attorneys in Europe with offices throughout the UK and in Germany. Originally with a background in electronics, in recent years, Jacob has shifted his focus to protecting software, which includes working on many artificial intelligence and machine learning related applications. So with that, I would like to let each of our panelists have a brief moment to share their background and a bit more about what they're excited about when it comes to our topic of the future of innovation. We'll start with Dr. Vishal. I think if you're comfortable here, we could stay here. It's up to you.
I know, I'd like to
Go for it.
I mean, the presentation that I have, right?
They have you queued up.
Is there a clicker? Okay. All right, so with the introduction that Denzel already gave, with my expertise in networking and systems and reverse engineering and strategic IP, I'm just going to kind of take you through the lessons from networking and telecom and how I believe they apply to IP and where there are commonalities. So first is that AI is here to stay. Okay, this is a statement made by Kathy Vidal, the USPTO director last year, that already 50% of all the technologies they're examining have some form of AI. embedded in the inventions, and 18% of the applications were related to AI. And so, and interestingly enough, even the USPTO uses AI to streamline its own examinations, and they're looking at it very strategically as a way to add depth and rigor to the examination and approval process, because they're getting, obviously at this point, something like 600,000 applications a year. And so the lessons that I would like to highlight, that go from networking and telecom to areas in biotech, and I've classified it into 4. So the first is, how is AI and IP strategy used in networking? And I'm going to then sort of flow back to what are some of the issues here that will be very similar in the biotech world. So for example, just to give you a quick rundown, the investments in 5G are projected to be about $600 billion by 2025 by the GSMA, which is the Global Mobile Association. And $200 billion of investment will happen in AI, according to Goldman Sachs. So clearly, there are 5 key areas where investments are happening, which is 5G, IoT, edge computing, and data center networking. And just to give you a flavor of it, Cisco, for example, is using it for predictive maintenance. Ericsson is using it for optimizing network slicing in the 5G RAN, radio access network. Nokia is using it for mobile traffic optimization. In fact, a great example of that is that they were just deployed, their so-called self-organizing network was deployed in the Hajj by STC of Saudi Arabia, which is one of the biggest operators in that region. And they were able to get a 40% increase in traffic supported with a substantial reduction in cost, a great energy efficiency, through 10,000 AI-mediated corrective actions that they were taking as the traffic was happening in the Hajj. And similarly, the hyperscalers of the world are using it for data center optimization and energy efficiency in data centers. The Tencents and Alibabas of the world are using it for content networking and so forth. But the big lesson that is important that is going to be in terms of the scalability of AI. How do you scale AI itself? That's going to be a common challenge given the big data sets that biotech deals with. The integration with legacy systems, obviously in the biotech and pharma world, there's a lot of legacy, and integration with that is a key challenge. Privacy and security. In the telecom world, you deal with customer data. In the AI world, bio world, you're obviously dealing with critical patient data. And how do you keep that secure? How do you maintain privacy? How do you still comply with various standards? And finally, it's bias. Anything that's customer facing, for example, AT&T and Verizon use it for customer data analysis and customer retention. Similarly, in the biotech world, you have a lot of customer patient data. There could be bias in the analysis you're doing, and how do you eliminate that bias to make sure that the conclusions you're coming to are actually sound conclusions, even if they are AI supported. The second thing is, since I deal with reverse engineering of telecom systems, reverse engineering is a common thing that's used in the biotech world for a variety of things, like new discoveries, infringement detection, infringement analysis. With AI helping you, you can do this process way faster than what has been possible so far. And for example, there was this famous case of CRISPR where there was a battle between MIT and Berkeley, and they used a lot of reverse engineering to determine what were the exact inventions from the MIT side and the Berkeley side. And now the same thing will be used using AI or otherwise, to basically figure out how are you going to analyze large data sets. A good example is, the Watson system developed by IBM was used by Pfizer in the 2016 to 2022 timeframe to mine through a huge set of data. Watson itself ingested 4 million Medline articles, 1 million full-text articles, and I think about 1 million plus patents. And it combined it with Pfizer's proprietary data to do, again, new drug discovery and analysis of things that you could repurpose drugs, for example. And that's an example of AI in action. But again, you have to meet the challenges of sort of the complexity of the system that you're dealing with. The next thing is, AI patent, there is a great deal of patent complexity when we are dealing with these biotech patents on advanced technologies. So one of the things that's going to require is a specialization and a careful drafting, it's going to change the landscape in terms of how the patent system itself works, from the patent attorneys to the inventors. People have to be conscious of how they're doing claim construction, how are they dealing with defensibility issues, licensing issues, and how are they going to protect their inventions should they be subject to litigation at a later point in time. And with AI involved, you obviously have to think about how are you going to actually craft a patent application that can deal with the involvement of AI while still passing muster at the EPO or USPTO. And a good example of this complexity was the Humira battle, which was Amgen versus AbbVie, where the biosimilar by Amgen was approved in 2016. It took another 7 years for it to hit the market. It only came in Jan 2023 because there was a 100 patent thicket that Biogen had built, AbbVie had built around Humira that Biogen had to navigate using reverse engineering and a variety of strategies of figuring out how they're going to have a biosimilar that doesn't use the same, the same kind of techniques, and at the same time negotiating patent settlements with AbbVie as well. So therefore, drafting of the patents will be very, very critical in my opinion, and working around very judiciously. And then the last thing I want to talk about is that we are all familiar with the standard essential patent battles between Ericsson and Apple, and Ericsson and Samsung over the last 10 years. And the issue I see is that same issues could arise in the biotech world, especially with the AI complications. So for example, there are ISO standards that cover the quality of management of biobanking of biomaterials. There are standards that cover medical devices. So if, for example, a patented method of DNA sequencing or a proprietary CRISPR application becomes essential for maybe complying with a certain standard, then now you're going to have similar SEP licensing issues in the biotech world that we've already seen in telecom. And so that's going to create issues of what is a FRAND rate, who has to license from whom. And I see that AI will be involved both in the creation of the IP, but also maybe in the analysis of the IP to help with resolving some of these SEP issues. And for example, the last thing I want to mention is that you have AI systems for analyzing genomic data, and if some basic analysis process becomes a de facto standard as this thing progresses in the next 5 to 10 years, then you will have SAP challenges based on who gets to use those standards and what is the cost of using those standards. So, and then here's a biotech innovation map that was there online, which I thought was very appropriate for us. It lists the top 10 trends, but really it's worthwhile to look at the impacts of the top 10 trends. And as you might expect, AI and big data, the two are the most influential trends seen in biotech in the coming year. And they pretty much touch upon every other area, from precision medicine to tissue engineering to gene sequencing and so forth, which are exciting areas, some of which we'll hopefully be able to cover with my colleagues in the rest of the panel. Thank you.
Thank you. Next we have Deepti.
Hello. Yeah, thank you, Vishal, for the wonderful insights. And certainly, as you said, that over a period of time, AI is going to be not replacing the patent attorneys, but supporting patent attorneys in doing the analytical work, or I would say screening work, documentation work. So we recently attended a couple of conferences. One was BioTechX. It was in Philly area 2 weeks ago. And we talked to companies over there. So everyone was so excited about use of AI in biotech area. So according to the big companies, they said that around in next 5 years, they'll be trying to automate most of the processes they have been doing in-house. And in the last week IPO, it was highlighted that, yes, companies are trying to use AI for internal processes, specifically IP attorneys, but I think the growth is slightly slower than how the R&D and other processes have been taking
the use of AI. So that's my personal observation based on talking to the people. But let's see how the IP is going with respect to the AI-related patents. So as we all know that conventional R&D, it has multiple challenges in terms of the cost, low data success. But AI has certainly given a support here, because the kind of the data that has been generated by proteomics, genomics, and analyzing that data, driving insight out of that particular data, AI has been playing an important role. So coming out of the consulting company, we thought of giving you an overview of how the trends are looking like in IP. So if we look at the trends in last 5 years, we find that yes, there is an acceleration in terms of the patent filing in the AI related to healthcare. In healthcare, we have considered biotech, medical devices, and pharma. Out of these three sections, a majority of the focus has been on the medical devices. So as we all know that medical devices, AI term has been used for last 30 years. It's not a new term. And in fact, the first AI-enabled medical device was approved by FDA a couple of years ago. And if you look at the current scenario, I think more than 600 medical devices that are enabled by AI has been approved by FDA. So we thought of segregating this medical device section from biotech and pharma. And the next focus here is towards the pharma, where in the pharma space, if you look at, majority of the focus has been with respect to the drug discovery. So if we look at the traditional drug discovery, it takes approximately 15 years in getting a drug approved by FDA. But if we try to look at the success that have been made by AI, I think the term is going to be reduced by 8 to 10 years. So I think these are the major two areas where AI has been playing an important role. If you look at the geographical perspective, we find that China has filed maximum applications in AI, and the grant is also maximum for China, followed by United States, India, South Korea, Japan, and Europe. So I think the innovations that are coming out of China, they are multiple, and approximately in all sections that are there in biotech, China has been covering those sections. In medical devices, as I said, the maximum focus is in the medical devices. However, the key area is the medical imaging, where most of the patent applications have been filed and published. So if we try to link it with the business perspective, we find that in the near short term, predictive healthcare, early cancer detection, and invasive CT scans, these are the areas where there would be commercialization of IP. In the midterm, Gen AI using combination of imaging biomarkers for early detection and COPD, diabetes, Alzheimer's prediction, they are going to take over the commercialization aspect. And the patents that are being filed in the AI with 3D printing for organ regeneration and AI-guided robotic surgery and virtual biopsies, they will be taking over the commercial space in a longer term. When in pharma, as I indicated earlier, drug discovery has taken majority of the share. However, other aspects like antibody designing, cell line development, bioprocess optimization, data mining, microbiome engineering, and immunogenicity prediction, these are the core areas where most of the patent applications have been filed. But if we try to link the recent applications with the market potential, we strongly predict that in next 3 years, we believe that AI for epigenetic drug development or quantum computing aided molecular simulation and enhanced drug repurposing, they are going to be commercialized. In 3 to 5 years, according to our analytics, automated AI robotics and neuro-AI interface, cross-species genomic translation would take over the market. And in next more than 5 years, we predict that biomarkers where extensive research has been going on, there will be commercialization in this space along with the microbiome engineering. So we at Ingenious and NCMind, we support patent attorneys, patent professionals, R&D professionals in performing various types of landscapes, infringement analysis, licensing opportunities, patentabilities, prior art searches, and most importantly with addition of Gen AI, real-time monitoring, what has been happening, what kind of additions have been happening across any portfolio they have been observing. With ingenious e-brain, of course, we do all these things, but the core aspect here is that we have PhDs, we have team who can analyze critically the patents that are related to AI. So our experience says that the patents do not talk about AI as a term, even in the claims or in the specifications. We have to read critically. Sometimes they talk about the end product, and then we have to look at the specifications where they might write about any kind of software that has been trained over a period of time, or any kind of software that can be trained over a period of time. So we do have such capabilities, and essentially it is, our experience says that over a period of time, the kind of filings that have been happening, they are not direct filings. So essentially, let's be careful about such applications so as to protect you guys from any kind of freedom to operate issues. So thank you so much.
Thank you, Deepti. And last but not least, we have Jacob.
Perfect. Hi, everyone. I'm Jacob. I've got a little bit of info from Denzel, but just to reiterate that I'm a UK and European patent attorney based in London. Initially, my degree was electronic engineering, because that was sort of my background. But equally, I've been doing a lot of software patents, and then sort of in the last few years, really moving into AI and machine learning as well. So just a little bit of background about trying to get protection in the UK for those who don't know. So we can sort of go through the UK IPO filing route, or we can go through the European Patent Office, that's the EPO. So ideally, you'd hope that both would treat AI and machine learning inventions exactly the same, but it seems to be that so far that's not the case. So it's important to sort of see the nuances between the two and how that's changing. It seems to be that every few months they'll release some new guidelines, and that's usually driven by case law, so we really need to keep an eye on how things are changing. I just want to flag here, we've got the UPC as well, that's the Unified Patent Court. This is not a filing office, but this is a new court system that we have here in Europe that deals with infringement, revocation, and other matters like that. So it gives a single court ruling for the whole of a European patent, rather than the current or the previous system that was each national office would sort of work individually rather than as a whole. So it'd be interesting to see how that works in with the UK and the and EPO as well, because since the UK left the EU, we're not actually part of the UPC as well, so that just adds another complication to it as well. So moving into the EPO, their guidelines for AI were released early this year. Some interesting things to highlight here were they stated that the mathematical methods and the training data used by AI or ML inventions should be disclosed in sufficient detail to reproduce the technical effects. So that sounds a bit daunting. Thankfully, they were saying that they actually want us to describe the training data rather than actually include annexes of thousands of pages of training data. So that's a good thing for us patent attorneys for sure. But it seems to be that we need to make sure that we keep sufficient detail in these applications. So I think we want to be more detailed than the other way around, because we could come up with some sort of insufficiency objections. And I've just noted here about the weights of the AI and ML models here, because so far it seems potentially they are not protectable, but equally, do we need to include them in the applications themselves, or do we want to keep them as a trade secret? Something to think about for sure. Then moving into the UK, guidelines also released for AI in May of this year. However, they've already been temporarily suspended due to a recent decision. This was actually in the last few months. The UK IPO versus emotional perception AI. This is actually at the Court of Appeal in the UK, so quite a high court, to do with emotional perceptions. Patent for is an artificial neural network based tool, so ANN based tool for recommending a song choice or songs that are similar to each other. And at the end of it, the Court of Appeals say pretty much that AI is just another computer program after all. So it needs to be treated as other software, treated as other computer programs. So as we know, we can protect software and we can protect computer programs, but there have to be certain technical effects and technical advantages associated with them. However, one sort of quite interesting thing to come out of this case was that the UK IPO guidance sort of indicated that a so-called better neural network could be allowable. And I won't go into too much detail or bore you on what that really means, but the outcome really is potentially it might be more favorable for an ANN-based invention to be filed at the UK IPO rather than the EPO. But that is pretty much a current thing, and who knows when that might change. So we need to keep our finger on the pulse there. And then this is just a final side of my sort of personal excitements and concerns surrounding AI and biotech to some extent. I also do quite a lot of work in telecom, so echoing what Vishal said about AI and integration into cellular networks. As we move into 6G coming forward, it seems that these companies are really pushing on moving AI both on the network side and on the consumer device side. So it'd be interesting to see how quick we can actually get with our communications and hopefully more efficient as well. Less so my area of expertise, but it's still really, really interesting to see how AI can be used in medicine to speed up drug research and things such as that. And then maybe an AI and biotech combined field in wearable health devices. You know, the Apple Watches, the Whoop devices, everyone loves these devices. Everyone likes the data about their, you know, sleep, heart rate and whatnot. But equally, I've also seen some things come across my desk of devices that can also, say, measure biomarkers coming off the skin, which can also like be used to determine whether like the person may be having a seizure soon, high, low blood pressure. So that's really interesting for me. And then finally, one potential problem or concern is just the high energy usage that we're seeing with AI. Potentially very concerning. I know a lot of people are already talking about this, but as we move forward into the next few years, you know, potentially this could be a big problem. I know that the new GPUs that are being released, they're all being used for some really, really high power AI calculations. They can be maxing out at like a kilowatt in power usage per device. So something to definitely to watch out for going forward. So yeah, thank you.
Thank you, Jacob. So we wanted to pause here, and obviously we wanted to give each of the panelists opportunity to introduce themselves and kind of talk about what they're excited about as far as the future of innovation, but we really want this to be a dialogue. I've prepared some questions, but in the interest of making this interactive and understanding that you just got a lot of great information, I want to pause now and see if anyone had any questions or reactions to anything that any of the panelists have said so far. Don't be shy. Okay, if not, then I'll get us started with questions. But again, at any point, if you feel that you have a question or a reaction, please feel free to raise your hand. And we're really interested in a conversation here. So the first thing I think that I would like to ask each of you, in no particular order, is from your perspective, what are the biggest challenges involving AI and biotech in the current market? So you each have kind of touched on that, but what do you see from your practice or from your business, kind of the biggest challenges facing the market right now?
I could just jump in, I guess, from a patent side. It's just the amount of changing in guidelines and just how quickly it's happening. I know we're still sort of very much in the early phase of AI, but equally, it seems to be changing from patent office to patent office. It's not like a universal way that it's being examined. So, it's us patent attorneys that have got to keep our finger on the pulse and keep an eye on case law throughout the world, because it just seems to be changing at an alarming rate, and you can't really afford to not listen. Whether that's in the UK, Europe, but equally case law in the US as well, because I think it's gonna shape the world of IP in terms of AI. So I think that's a big challenge for sure.
And according to our understanding, we would say that data security is one of the aspects, because as Gen AI has been taking over the AI, the kind of data that has been generated, the kind of insights that are being generated, every company wants to protect their data. They really, because we work with different companies, they want to use others' data, but they're not willing to share their data into the public domain. So probably some standards, if they can be brought in this area, because the kind of data that is segmented, there is no guideline as well how to use this particular data. So this could be, this is, I think, one of the challenge in terms of AI and biotech.
I'd like to come at it from a different perspective, which is that one of the challenges in my sort of thinking is going to be how you actually protect IP, which has been generated with AI assistance, and where that line is. And I know that's a well-debated topic, but I think it's in the finessing of the invention. Both the inventor has to be very conscious of it, as does, as Jacob said, the patent attorney themselves. And I know they're on shifting sands with regard to the regulation, but independent of that, it'll be in the way you craft the invention, not just to get the invention approved, but what's going to be the future? What is the litigation strategy might look like? What if something becomes standards essential, like I was just saying? And then, how does your invention stand up to it? That's one part. The other is, how do you really use AI effectively to speed up the discovery process, whether it's new drugs, whether it's analyzing drug repurposing, and so forth. And how do you effectively do that while, as Deepti said, maintaining patient confidentiality and security. So that's my take on it. Great. Sorry.
I think I'll just add to that, and I see your hand. I'd love to get your question or comment next, and I see you as well. Just what I'm seeing with some of my clients, so I have clients in the Gen AI space and outside general counsel to a few generative AI companies, as well as a few medical device companies that are using AI for detection. And one of the questions is big issues is data, right? We're talking about the patentability of what clients are developing, but there's also the issue of the inputs, right? And depending on how courts in the United States or abroad are treating the inputs, and whether you have to whether there are certain property rights to those inputs that you may be violating, and then whether you need to pay for inputs versus not pay for them is another challenge. Actually, where are we getting the data from to input into our various models is another one. But I'd love to hear your thoughts over here.
Yes, I'm thinking about, I do some, work in the justice space as well. And my experience, from South Africa especially, is, there's no coordination. There's, communications very little that deals with ICT stuff. There's a competition law or antitrust authority that deals with other things. There's policymakers and what we call the CIPC, which is your filing office, the IPO office. They don't work together. As we move along, there would be a communications authority that launches a paper, like you mentioned earlier, about regulations that are coming up, to try and deal with what we are facing now. But there's a lot of silos, and how can we best manage that to make sure that everyone is on the same page and we move, all of us, at the same speed?
Any reactions to that from the panel?
Well, I mean, that's obviously going to be a challenge, but then it has to come from the regulatory side or the, let's say, administrative side. As you see, the Biden, AI sort of prescription, it's a prescriptive regulatory kind of framework trying to at least highlight what the key issues are, data privacy, ethical use of AI, especially in biotech and pharma, and what is permissible and what's not permissible with regard to how you can, how far you can go with AI. So, that's at least a start in terms of laying down a framework and allowing the thing to happen. And then similarly, the USPTO, I just talked about Kathy Vital. They've been very active, holding sessions all across the US and the East Coast and the West Coast, trying to get the perspective of the inventors, the patent attorneys, the patent community as well, to try to see how they are going to change their or adapt their patent examination technologies and methodologies while allowing innovation to flourish. So there are these attempts that are happening, but of course it takes a while for things like this to gel.
I think just to add briefly to that, something that we're seeing in the United States is there are those of us, and especially those of you, who kind of understand the technology a bit more and kind of all the uses and the challenges. But a lot of what's being driven, what's driving the conversation here in the United States, and Jacob and I were talking about this beforehand, kind of differences in the EU and the US as far as regulation is, we're seeing a lot here is being driven by whatever public attention or popular opinion is into at the moment as far as regulation. So, you know, deep fakes and Taylor Swift became a big issue. Now, all of a sudden, there are lots of proposed regulations on deep fakes, which is just one potential issue. But I think it seems like here, I'm seeing that the government is kind of taking a ad hoc approach based on whatever the hot issue is at the moment, and not necessarily as systematized of a framework. But I'd love to hear from, I think, over here, sir, you had? Yes.
It's a more general question to our last speaker. Thank you. You said, if I understood correctly, that we should deal with AI as it is general software, right? So, because this is an ongoing discussion in the EU, I come from Greece, and under the upcoming directive, there is a discussion if the directive is going to be AI liability directive or software liability directive. Could you please elaborate on why this is feasible? Because AI is not a regular linear algorithm. It's an evolving and a self-learning algorithm. So there are a lot of issues there, and if we wrongly connect the two, we're going to have a lot of legal problems.
Definitely. I mean, I still think it's got, this is speaking from a sort of a UK and a European perspective, I still think it could definitely change. You know, we're just having the early decisions in case law at the moment, but they do, speaking from particularly this case I mentioned here, this emotional perception AI case, the judges in this case seem to think that even though AI is different to another computer program, it is still a set of instructions that is then run by a computer, and so that it still falls into that framework of it is computer program, it is computer software that is then running on a computer, which, you know, to some extent it makes sense, but equally, as you mentioned, it is different and it is evolving. So I wouldn't be surprised if as things go on, people have better arguments to present to these judges potentially. Because one thing to think about, I don't know if it's the case everywhere, but these you know, the judges that are making these decisions, sometimes they're not even, you know, technical experts themselves. They're legal experts. I think that's even more so the case in the US. In the UK, for example, typically they are more specialist technical judges, but still nonetheless, these are extremely difficult cases they're residing over, and even the experts themselves are, you know, it's hard to sort of get across what your, how great your invention is, and then to just try and describe that in court. I imagine it's extremely difficult to try and get that across succinctly. So I wouldn't be surprised if going forward we do see some changes, and whether they actually, like you said, maybe come up with a new section. You know, it's not a computer program for a computer, it's specifically AI. Because you know, once upon a time there was no computer software, so equally, why not create a new, you know, a new niche? I don't know. That's more speculation, really. But yeah, thank you.
Actually, that's a very good point you made, because there is definitely a danger in treating AI exactly like software, because it's non-linear. The aggregation and dispersion algorithms inside the deep neural network, they are operating on non-linear functions. So you're not going to get, you may not even get the same predictable performance every time if you run the same set of data through it. And that is a very important distinction. And it's going to be hard to do that, because there is this push, and it'll come up. I don't want to kind of burst the next panel, but you know, there is this idea that it can be like software in some cases, yes, but there are critical things where inferences would have been drawn, where it will be, perhaps have to be a class by itself. Because you're exactly right, because if we sort of, you know, treat everything with the same kind of brush, it's going to lead to a lot of different problems when we start litigating AI you know, invented applications and AI-based patent applications. That's kind of my perspective.
Thanks. Any other questions? Go ahead.
Do we have any other question from the audience?
No? Okay. So I think we're kind of talking about the developments in the UK and the EU, in the United States, and kind of, I think a lot of this conversation of the future of innovation is about strategizing, right? How do we advise clients if we're attorneys? How are we positioning our business if we're running a business? So I guess one question is, how can patent and trademark analytics, and some of our panelists have already kind of talked about this, but I'd love more detail about patent and trademark analytics and AI-powered tools help companies, including biotechs, optimize their IP strategies and portfolios.
So I think AI-based analytics is going to support the companies at every stage. So starting from conceptualization to commercialization, these AI-based technologies can support. So earlier, if we see data extraction, data analysis, past data, prior art search, it used to take lots of time. But with the support of AI, I think the data extraction can be accelerated. Analytics could also be accelerated. However, they have to be focusing upon training the tools as per their subsection. So what is happening right now is that companies have been using AI for streamlining their processes. So first they are trying to identify the processes. Let's say in biotech space, if I have worked closely with biotech pharma industries, for example, biopharmaceutical process development. So they were trying to segment this entire process. What are the different stages, whether they can have any external support and can develop their own AI tools. So processes have been streamlined up to some extent. The companies have taken support of different big giants as well, if we talk about the big biopharmaceutical companies. However, with respect to the sub-technology areas they have been working, I think they have to design some kind of internal database so that they don't have to wait for any external sources to give them recommendation. But over a period of time, whatever areas they have been working, whatever domains they have been working, whatever future directions they want to go, they should try training those modules so that they can save time in any kind of activity they have been performing with respect to research and analytics. So I think this is going to save their time and future.
I just wanted to add two things. I think that with big data analytics, it expands considerably the scope of what a company can look at as an invention space, because you can digest and analyze so much more data. So you can, let's say, correlate all the prior data to discover new uses of the same drug, or discover certain molecular pathways or protein interactions that would have been unknown and very hard to do without the presence of AI. So that consciousness, that space has expanded, and the universe of invention possibilities has increased, is valuable, because now people can go into a part of the state space that they wouldn't have gone in and create new inventions. And the other is how they can reverse engineer their own processes, because as Deepti said, it'll be a lot faster, a lot quicker. So now you can reverse engineer things that you couldn't have done before because you have so many ways to analyze it. And that helps you both to develop better patterns yourself, but at the same time use the exact same techniques to reverse engineers the competition's patterns and break them apart more easily than might have been the case otherwise in biotech.
Makes a lot of sense. And Jacob, I would throw it to you. Just we've heard from the other panelists. I wonder if you have any thoughts or observations about ways that people may be using AI or data analytics in the patent process overseas.
Yeah, I mean, I could touch on, I guess, AI tools as well, particularly for patent attorneys. It seems like this is a sort of a new space that's coming into fruition now. I mean, I personally haven't tested any myself, but some of my colleagues have, and it seems like we may not be fully there yet, but equally these AI-based tools could be very useful for analysing prior art documents that have been cited during prosecution, potentially even drafting applications. So, you know, I guess as you know, the internet and the computer helped, you know, patent attorneys. Thankfully, I wasn't actually around at that time, but you know, how that's helped, you know, reduce the time it takes for them to do each, you know, each draft or each response. Potentially, this could help us reduce the time it takes, and then, you know, pass those cost savings on to our clients. You know, potentially that could mean they have more budgets for R&D. You know, hopefully that could, it could give them more budget to be able to work on their R&D, and hopefully things can flourish in that, from that side. So I'm excited to see how AI tools can help us in our job, and then pass those savings, onto the clients.
Great. And I want to pause here and pose a question to the audience. So first part of the question is, if I could get a show of hands, and please don't be shy, how many of you are practicing attorneys either in the US or outside the US? Okay, a lot of us, right? And then in any of your practices, and feel free to raise your hand, are you seeing either in your own practice or colleagues this same, what are your experiences as far as using AI and technology for the actual patent process? Is anyone using it? Yes.
Hi, yes, I'm Stephen Sullivan, technology industry leader of Schwabi. I've tested out a few Gen AI products for patent prosecution, and what I found was, our firm requires us to get a waiver from a client to actually use AI, and two, we vet the AI, for confidentiality, all those things. And what we find is most products on the market today are good about the confidentiality. They're not going to ingest your client data and train their LLMs. Otherwise, they wouldn't get any clients. That's number one. Number two, the way we tested it was I used an application I drafted before and input all the data that I had when I drafted it into the AI to see what it would come up with. And what I found was it's great at summarizing, which is all LLMs. They're very good at summarizing and coming up with a decent claim one, a little bit too broad, but decent, probably good for provisional. But they're not great at getting the small nuggets of details that the inventors drop, but don't really expound on. So some aspects of the invention just weren't covered at all. So it's almost like the output was what a first-year associate would give you that didn't have any patent training, but enough to get you started. So that's what I found.
Thank you. Yes. We have one right here.
I actually used it ahead of this conference just to fool around and see how it works. And I did something very similar to what you did, was that after drafting an application, I fed in as much input as I could basis what I received from the client. And I've had pretty much the same experience over here. It will give you, it will draft a claim for you. It will even draft a dependent claim for you. But the amount of work I have to put in order to fix what it's done is no different from me having to rework something someone very junior has actually done. So it's coming along, but and there's no way AI can actually draft a response to an office action. Yeah, it's not there yet, at least from the little bit of experience I've had playing with it.
I have one question for both the audience members. I mean, did you use a generic AI or did you use something that was more specific for the legal world?
Yeah, I don't recommend using a general. You wouldn't use ChatGPT to draft a patent application. That's a breach of client confidence. But yeah, that.
I used something that was presented to me for a trial, and it was legal specific and drafting specific, yeah, this is what I got.
So I think that will depend on the amount of how big of a training data set these LLM models have had, and as they get more of it, there's definitely be an improvement in quality, although perhaps not necessarily competing, but aiding much more experienced counsel.
Just to jump in, I think it will be difficult to sort of replace the experience of an attorney, because whenever you're drafting, you're taking in everything you've done in the last couple of years, potentially new case or other things you've discussed with your colleagues. For me, it seems difficult that a computer program, even if it is AI-based, could ever really replace that. I think, as you mentioned, that the summarizing, potentially, yes, and often you go through and you do keyword searches. That's sort of the basic of my, helping the computer to help me, analyze prior art documents. So I think an AI tool could help in that regard. But the actual drafting process, right now, I feel like that would be difficult for it to do. And especially, I think that would also assume that you have the perfect inventor giving you the perfect details of everything in the invention without you having to, really drive down and try and get everything out of them. And I don't think that that's ever going to happen. You never have a perfect disclosure from an inventor.
Especially I work a lot in engineering and software. So I'm doing a little bit of artificial AI-based mental health related patents. And I've noticed one thing, that a lot of the inventors who are engineers are very poor communicators in the written form. You know, so it is literally, you have to actually be a method actor and put yourself in their head and try to think like them and kind of actually invent for them. So, you know, with the kind of information that I get from my inventors, I'll get even poorer results from the AI that I'm working with.
Yeah, no, I totally agree. I think it will be difficult to ever replace the attorney. Well, I would say that hopefully, hopefully won't get replaced. But yeah.
Small remark, I don't need the mic. It's a small one. Their role could be complementary, not competitive.
Exactly. Yeah.
And I think the point to mention over here is that it does help you hit the ground running. You know, so it does save you a little bit of the initial work when you see it put together a little bit of information. You know, and it does to that extent. You know, AI has been useful. And how it evolves, we don't know right now.
Yeah, we'll see.
Yeah.
We have one question from that other corner.
Actually, on the same topic, yeah, I've actually tested out about half a dozen different AI-assisted patent drafting tools, and basically my thoughts are it's consistent with what the other speakers have said, which is that it's okay, but it's not really there good enough. Right now, it would take longer to really draft a good application by using an AI-assisted tool versus just drafting it yourself. And a key part of that really is what the speaker just said, which is that you don't have perfect information, so it's a very iterative process. And a good patent attorney knows how to do that, whereas the typical AI systems are said, it's assuming you've drafted something perfectly first, and then it'll do something. And that's just not the reality. So I think that we're going to get there, and this is a question of how quickly we're going to get there, and we should all be watching it to see, to make sure that we're using it when the tools do get better.
Right. I think you were kind of a lot of commonality and experience as far as the use of AI. And I'll just add to this very briefly. Again, my background is not intellectual property, but for attorneys who practice, who work in my practice areas, corporate transactional work, a lot of them is kind of a mixed bag, but a lot of them are terrified by AI. And the reason that they're terrified is to the points that so many of you have so astutely made. First drafts of things, a lot of what we do is from forms. And so, taking a form, getting information and putting it into a form, typical work for a first or second year associate in a transactional practice, AI can do that pretty much now, and it's getting better by the day. So especially for corporate transactional work, a lot of attorneys are afraid of AI. But to your point, I think it's similar in that the human aspect, the judgment, right? The follow-up, being able to actually interact with that engineer. And knowing how to ask questions of the engineer or the more tech-focused person. Knowing what to follow up on, and also, yes, not just summarizing, but taking the summary of the facts and actually making it something useful, making a recommendation is still something that, people are needed for. Sir?
I don't do any patent prosecution work, but I've been on the litigation side a couple times. And I know one of the tests is obviousness of combining stuff. So is the test going to be now in the future, if an AI system would come up with these patents and hold them to be related, is that going to be indicative that therefore it was obvious to combine them? And how is that going to affect litigation strategy if I can, humans can't go through and read every patent that's ever been issued around the world, but computers theoretically can and would find a whole lot of things, and an AI system may say, well, we would combine these potentially to come up with this invention, and I'm wondering if anybody wants to comment. How that's going to affect
That's quite interesting and scary point. If they sort of, I think firstly I'd say that they'd have to change the legal tests if that was the case, because in most countries and jurisdictions we have the fictional sort of skilled person or person skilled in the art, which at the moment is not an AI. It's sort of a fictional person with a decent knowledge in the field. So I think if they were going to try and say that, well, then AI could combine these, and so then that would be obvious.
Would that skilled person use an AI system?
Potentially, but I say at the moment, I don't, these aren't the tests that they're going through, and so they would have to change, and they might change. I think pure speculation, but if people can't start coming up with all these amazing inventions, and that actually it's just that AI has done it, it'll be interesting to see if they do change it in the future. That's an interesting point, scary point, but yeah.
Lisha?
I would just say that AI has been tremendously useful in identification of litigation. So as you said that it's not that possible to analyze all the patents, read all the patents. However, if you look at the infringement identification, litigation identification, if tuned properly, again I would put a disclaimer, if trained properly using the specific data set, I think AI has been able to identify infringement up to some extent. This is what our experience says with the database we have been using. So probably it might support attorneys in...
Have you come across AI that can actually do claim charts?
Not really, not really.
So,
Not so far.
sir?
Denzel, I only wanted to add, filling out forms is exactly what is currently helpful. In Germany, we have a court who deals with travel compensation. That means if the airplane is late, and they analyzes from the attorneys all the paper and say which category is it, which kind of delay was there, and they fill out already some kind of forms, and afterwards the judge just looks over and says, okay, is it justified, is it well done? And then it a little bit accelerates the procedure in some areas where it's quite formally, because the case law there in Germany is quite, that means you can predict what happens under these specific circumstances.
That makes a lot of sense, particularly in, I would think, civil law jurisdictions. And common law jurisdictions, again, the ability to analyze cases is useful, but I think especially
with inventive step it does not work.
Exactly.
But
yeah, and in the case in Germany with travel compensation, how much deference are judges there showing to the AI? How much are they going behind?
I do not have details, but it was interesting for me. That means that this kind of work already is done by AI, this pre-filling out the forms and the categorizing, even if there's 15 pages of attorney work, and they analyze it and it already goes to the courts in a filled out form.
Thank you. I think we had
one thing to add to
So
the
we have
question
one
that we
question.
started with. One is that it doesn't matter, in my opinion, whether AI is finding those patents or not, because the thing that is going to protect that kind of an argument is the fact that you can't reverse engineer. You can't look at the patent, look at 3 related patents and say, oh yeah, it would have been obvious. As Jacob said, it has to be obvious to somebody skilled in the art. And that happens very often in the patent office. And to your question, the patent office examiners are actually using AI now. And this is the exact reason that they can look at 500,000. Actually, I forget the numbers. It's a million plus or several million plus database that Google has worked with the US Patent Office to train that particular system on. But that's not, that will improve the quality of patents processed. But this argument is still going to be valid. You can't reverse engineer the whole patent by looking at the claims and saying, oh, this would have been obvious. And that has been happening with the patent office always. When you get a first-time rejection, I've looked at many of them where they have collected some patents, and invariably you have to defeat it on these grounds. And eventually, if you are persistent enough, the patent examiner will kind of concede and recognize that they were reverse engineering it. That's one.
Not
and then in
always.
jest, I might say that if you needed AI to actually find the patents, then that right there should defeat it, because no human can do what the AI is doing anyway. So there was no way for somebody to have combined it, even if they were skilled in the art.
I think we had a...
Yeah, so I just wanted to respond to the question about the AI doing claim charts. I have seen that happen. I was at IPBC a couple of years ago, and I think it was Xperi had a platform that did that. I went up to the booth because I knew the person who was at the booth, and he said, give me a patent number. So I gave him a patent number, and then he talked to me for like 10 minutes. At the end of 10 minutes, his computer spit out an infringement chart. Now, obviously, I would spend hours going over that infringement chart to make sure it wasn't garbage, but as somebody who's done a lot of patent assertion work, a lot of the work that you do in that is just finding the infringer, and then you figure out if they infringe, right? So if that could at least save me a couple of days of doing that, I think that's out there. Also on the on this combining obviousness reference topic, you know, it used to be the law that if all of the elements of a claim existed somewhere in some combination of references, then it was obvious. One of my favorite Federal Circuit cases was Dembachak. It was the invention of a garbage bag that had a jack-o'-lantern face on it, and the patent office had said, well, there's garbage bags, and then there's paper bags with jack-o'-lantern faces on them, therefore it's obvious. And that's where the motivation to combine test came from, was that case. The court said, no, like the fact that it exists doesn't mean it's obvious to combine. So if we somehow get to the point where AI can combine any two patents in the world, regardless of how related they are, because it can find, you know, all the patents in the world, that would totally wipe out that test. And we would be back to the pre-Dembachak idea that if you could find the elements somewhere in the world, then it's obvious. I don't think the courts are going to want to do that. I don't think it would make sense. I'm done. This way.
Any other questions, reactions? Over here.
We talked about whether AI can replace patent attorneys in drafting applications, and I think everybody agrees that that's a long ways off. But I think there's a second question that might affect us more, and that is whether AI can replace attorneys as the gatekeepers to filing patent applications. Or in other words, are people who can afford our collectively high prices going to use AI to draft something that's not as good as what an attorney could produce, but good enough for what they have money to do, and file that with the patent offices of the world? And if so, how is that going to change our profession?
Yeah, I think that's definitely a good point. As we've already highlighted, you know, you shouldn't do it, but I think ChatGPT can, if you post it in like your invention, I think it can spew out something that looks like a patent application. You know, it knows the different headers to have and the different sections it needs. You know, we would always advise our clients never to do that, and of course we'd hope that we would do a better job than that. But equally, I guess you could, in theory, you could, if you didn't have the money to hire a patent attorney, you could sort of use these tools to be able to draft an application and then file it in your regional office. You know, you don't need us to file an application, so potentially could happen. I don't know whether that's going to become a big trend. But equally, I think if you're serious about your company, you're serious about the investment you've made into this R&D, typically, you know, you want that to be protected in the best manner possible. So I'd assume that it will continue to be as it is now, and you'd hire a reputable attorney to represent you. But I could be wrong. I don't know.
I think that one thing is that you also have a better filtering process at the PTO now, right? So if you are generating a poor quality application, hopefully it'll be rejected at that point. And then, of course, the old adage goes, right? You get what you pay for. You get free ChatGPT, you get a free application, garbage in, garbage out. So, but on a more serious note, it would be rejected, you know, hopefully at the USPTO because of the generalities of how things are drafted, as we've heard from so many of the experts.
So,
I think with the kind of documentation software that are there, probably the filing, prosecution could be automated over a period of time. But as far as our understanding goes, working with IP lawyers, they are little skeptical. They don't want to share the knowledge that easily. So according to my understanding, prior art searches, search part, analytics part could be automated by AI. But once it comes to patent drafting, prosecution, responding to office section, I have also not seen any software which is doing claim charting. There are many claims, but once it comes to mapping of the claims with respect to the prior art, you have to have, because the tools that are there, they work on a specific algorithm. You can define the keywords, you can define synonyms, you can define occurrence, you can define placement, but the inference that has been drawn out of a claim, it's very difficult for an AI software to do as of now. We never know the future, how it goes.
I should mention, however, that on a recent LinkedIn thing, there was an attorney, analytical attorney, who actually did an analysis of the patent applications in the USPTO from November 2022 through like summer of this year. and they found an increase, a perceptible increase in chat GPT-isms in the applications, which could not be explained by any other thing other than chat GPT bursting on the scene about 18 months ago. So the fact that people are using chat GPT to draft applications seems to be happening. Now, whether those applications make it and we get good quality patents remains to be seen.
I think just focusing on that, I mean, if these new companies, new startups are trying to get protection for their innovations, I would assume that if VCs, if they're trying to get funding for for their companies, if they then look at the application and it looks like it's been written by ChatGPT, I can't think that's going to reflect well on the company. You're not going to look very serious if you've used a free program to write your patent application, and potentially it's going to get potentially going to get rejected. I mean, it could get granted if it's a brand new and innovative thing. It could be granted, but equally, I feel like companies wouldn't want to risk something so important on some free software. So we'll see.
I think that that's true, but I also think that there is both opportunity and challenge with the use of AI. There's a potential it could democratize and kind of open up legal services to people who previously couldn't, and I'm seeing versions of that in other spaces, like for example, landlord-tenant claims in New York, for example. But there is also the risk of people using, ChatGPT Esquire, right? I was just I was helping a startup client remove a independent contractor they were having some issues with, and as part of that, part of her equity was getting clawed back. And she sent this very long, bullet-pointed, detailed response email, and my client freaked out. And I was like, wow, okay, I guess she hired a lawyer. Okay, that's fine. But then I looked, and to your point, you can kind of see the chat GPT-isms even in there. I'm like, yeah, she didn't write this. So I think that there's a challenge, and then there's also an opportunity. I think that there's a positive, and I personally embrace, AI being able to replace some of the lower level things I do, even if it takes away from my business, because, I can add value in other ways. And that's my perspective on it, but people feel differently. We had two hands over here. Yes.
First of all, my point is similar to yours, because these technologies are bound to democratize the process. When the dilemma is between using an actual lawyer and an AI lawyer, you'll have to do with people with small funds. So instead of making them go away from the process, we should focus on certifying the tools that they use as legal professionals, pushing for certification of the tools instead of, again, seeing them as something competitive to our work. We could be certifying a low level of the process and then be complementary to the rest of it.
Yeah, but I think I sort of touched on it earlier. I think patent prosecution, patent drafting is extremely expensive, and it does, it leans towards the big companies. It's hard for the individual inventor to get onto the patent ladder because it's so costly. So I think if we can use these tools to reduce our costs, reduce our fees, and then pass them on to the client, I think that can only be a good thing. And as you said, I think we're going to need that potentially certification, industry acceptance of these tools, to then be able to pass on these savings to the clients.
So real quick, I saw your hand, and then over here, he's been raising his hand as well. So if you wanted to, do you still have right here, and then in the back there. Thank you.
What I was saying was that at the very least, for someone who's cash-strapped, and I've seen this before, and I've conducted workshops where we enable our clients who don't have that kind of funding or who are not VC funded to be able to self-file a provisional. So now a chat GPT could be useful because you're just getting a placeholder, So it gives somebody 12 months. It gives them a year to raise the funds and come back to you. And it gives them that relief and potentially evaluation because they are patent pending, having filed a provisional. So it's not so bad, actually, to consider something like a chat GPT to do the basic stuff.
I think, can we get over here, and then I think we may be running out of time. Yes. Yeah. Thank you for your patience.
And meanwhile, just for everyone's information, if you use the paid versions of ChatGPT, they claim that your information will not go out, but you can use the entire information. So I would recommend patent attorneys to use the paid version if they have to really use it frequently, or they're associated with the law firms can have a single version of paid version of LLMs.
Thank you.
Thank you. Yeah, super interesting discussion. I'm from Solve Intelligence, one of the vendors building AI software to help with drafting prosecutions. This is all pretty topical for us. One thing I'd say, as has already been said, is that AI is not capable of just clicking a button and drafting a patent. Far from it. It has to be an interactive kind of process with the attorney, as already has been discussed. And I fully agree with what was mentioned on the panel, that the barrier to generating this initial output has clearly been lowered by AI. And so the onus is really on the Patent Office to be able to, make sure that only high-quality patents are being initially approved. And that will then, of course, mean that people need to continue working with attorneys, because these systems are really useful. They're valuable when they're treated as co-pilot assistants that help with the drafting process, doing a lot of the kind of more menial mechanical parts of drafting, for example, the specification, updating the reference numbers and so on, not as pressing a button and drafting out a set of claims. And I actually think that if you look at the way in which people today are using AI as patent attorneys, one of the things that often comes up is not that they're able to increase the volume of work that they're doing, or that they feel like the overall time they're spending on an application is being decreased. That does happen sometimes, but actually the thing that we hear a lot is that they're able to free up time they'd otherwise be doing a lot of these more menial mechanical parts of the specification, and then reallocate it to, for example, focusing on the claims. And so they feel like using AI actually elevates the quality of the patents they're able to draft for their clients. And I wonder if the same thing will happen with the patent offices when they're reviewing, they're already massively time constrained, when they're reviewing all of these applications coming in. AI will help them review a lot of these things and sift out a lot of the lower quality patents faster, and so the overall quality of patents might actually increase, both on the drafting and also on the acceptance side from the patent offices.
Thank you.
Thank you. Thank you so much. So we can continue with the question in the next networking break. So now let's have a round of applause for our panelists. And we would like to present a token of appreciation on behalf of IIPLA. So I request a moderator to honor our panelists.